Hey there, how are ya? Nice to be back. Happy 4th of July to all of those who celebrate the 4th of July. If you're in the US, if you're a World Cup fan, if you're enjoy the 4th. It's 250. That's cool. That's a quarter of whatever 1,000 years is. A millennium. I think that might be a millennium or whatever it is. That's 250 years. That's significant. That's not a young country. That's a mature country by now. So, congratulations to all of us on the 250th birthday. Notwithstanding whatever critiques I have various critiques, not only of the security system, but as to the political system in the United States. I'm fine with the political system. I'm not fine with the way the parties conduct their business. I'm not fine with unlimited spending in politics. I'm not fine with unlimited campaign length, etc. So I'm no fan, and I'm not a fan of either party. I think I've expressed that before. Dislike them both for various reasons. So that's kind of where I'm coming from. But notwithstanding that, I am so grateful to have been born in this country and think about it daily. And my parents had arrived a month before I was born, so I was kind of like later to be known as like an anchor baby. Although my parents became citizens, they had to I guess take an exam, and they officially became citizens probably in the early 1960s. I would say I was born in 1958, so my parents arrived by boat legally to the U.S. Um, in November of 1958. I was born December of 1958. And in the background, by the way, if you hear a little roar or whatever, I'm listening to the Canada Morocco soccer game in the World Cup in the round of 16 that I think is taking place in Philadelphia. I think it's in Philadelphia. Morocco, I think, was favored in this game, but so far in the first half, Canada has dominated. But it's still, you can dominate in soccer and still nobody can score. But Canada has certainly had the good run of play, as they like to say. And it's, I think, in the latter part of the first half. So if I see a score or something like that, I will advise you. I became a soccer fan when I was a kid because I had a cousin who liked soccer. So I like the World Cup, but nobody can afford to go there, and that's another story. So, wow. Before I start talking about GTII, I wanted to offer some jokes from Claude, and we have a new version of Claude. At least I saw it. So they kind of released the prior version. I forgot the name of it, that had been retracted because the government thought it was it was dangerous. So they did something. There was negotiations between the government, and now that has been released. But I think it's going to be more expensive. And Claude is Anthropic's model, but they have upgraded the prior second highest model, and that's what I'm using for the jokes today. So these are new jokes from a new model. I thought, most of them suck, by the way. But I'll tell you what I asked them, and then kind of throughout this more. I think this is gonna be kind of lengthy. I'm saying because I'm just kind of babbling on. So if I babble on, that makes it more lengthy. Feel free to check out anytime you need, as the Eagles would say. But I'm gonna kind of sometimes throughout my presentation here and discussion, I'm going to go through the jokes, and I'll tell you what I asked you. So first one was, give me some hilarious jokes regarding travel. Give me 5 of them. Gave me 5. I'm using the best 3. I told my suitcase there'd be no vacation this year. Now I'm dealing with emotional baggage. And I think I've used this joke before, and I found it funny, and it'll be slightly relevant to. This is going to be the largest introduction in the history of introductions. Just so, if you want to skip ahead, if you're watching it, skip ahead. Why do seagulls fly over the sea? because if they flew over the bay, they'd be bagels. And last but not least, what's the difference between a tourist and a local? About 3 wrong turns and a very confident wrong answer to which way to the station. So that's the first set. The second set is the instruction I gave was, how about better ones about travel to Poland? And it gave me 5, and I kept 2. I tried to order just water in a Polish restaurant. 20 minutes later, I had 3 courses and a shot of vodka I didn't ask for. And last but not least, the tour guides in Warsaw said the building survived everything. I asked what that meant exactly, and he just gestured at the entire 20th century. Okay, I'm going to stop there. And just to kind of briefly bring you up to speed, I was gone for a couple weeks. Where did I go? I went to a wedding in D.C. During a very busy time in D.C., and it was very hot. And then I went on a trip with I have 3 kids, all adult kids, very capable kids with their spouses. So that set, and along with 2 grandkids, we traveled to Europe. We went to London, where we spent, I think, 3 nights, and then we went to Poland. That's why some of these jokes will be relevant at some point in time. And then we went to Poland, where we spent 3 nights, and that was kind of a roots tour. Going back, we visited Auschwitz, etc. And I will have a separate video of that at some point in time in the future, where I'll kind of go through the tour. And I know many people won't ever go to these places, and even if it's just a travel log, it might be interesting to some of you. And I obviously will get in more depth, because my mother, I've mentioned this before, but my mother spent time in Auschwitz, which wasn't a very fun location, and she was lucky enough to survive. And that's why I'm making these stupid videos, and that's why I'm able to go forward on behalf of GTII, because my mother was able to make it through to this day. So but I was the only one in my family who was born in this country, so I do appreciate that fact. And again, I think about that a lot, how lucky I am and we are. So before I start, I told you it's gonna be the longest preview. Before I started, so when this is kind of, I get asked frequently and nicely why I continue to do this, because everybody knows, because I'm fairly open about this. I'm not getting paid for this. I've traveled, obviously, to Vegas and spent a bunch of money. I filed my own things. I got sued, had to do that, whatever. And people have asked, many people have asked why I continue to do that. And I said, in part, as I took on the obligation, I said I was going to continue. And I mean that. So I'm not going to stop where I have made I've made a promise to basically every shareholder that I will kind of be their representative to the end, wherever it is, and try to kind of accurately communicate what's going on. So that I did, and I kind of picked that up from the MMTLP crowd, because even though I had a very small investment, I felt the problem and the emotion and the fallout that accompanied that, and I was obviously sympathetic to everybody. So I think I was touched by that, and then GTII kind of I took the lead, probably because of the MMTLP thing. I thought I understated. I would say I was conservative in any allegations I made. Excuse me. You're sneezing, rubbing your eyes. I think I was very conservative in my speculation about what GTII has turned into. So I feel very comfortable that I at least had a sense that something was going on and I was accurate. I can't say that's true every time, but this one I felt kind of just based upon my interactions or lack thereof, and a long experience that like anything else, you do something long enough, whatever it is, you become very familiar with that area, and things that other people may not pick up, you would, because it's part of what you're doing. And it's true of whatever you do. If you do it enough, that's what happens. So I had that, and I felt kind of something, and I think it came out. And again, I tried to be conservative because it's better to be conservative, because it obviously turned out, I think, according to the receiver, it turned out to be substantially more substantial, that there was more stuff than anybody could have guessed, at least according to the receiver, because we don't really know, because none of us have done our own analysis of all the evidence, but the receiver in his reports apparently has, and they have counsel, and I know the counsels actively participated, because I was told that. And thank you for Fable 5, by the way, Gary. I was told that they actively participated, at least in the preparation of one interim report that was like 50 pages long. So I kind of speculate they've been intimately involved, at least in okaying all of them. And so I think they've been involved. But be that as it may, I decided to kind of take that on, and at the same time, and this is just how it is, I decided to try, and this kind of didn't start this way, but as I went on, and as people would question why I would do it, I decided that was a good way of making that point. Because of and my family background, yada, 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 that most of them got killed by the Nazis in Germany, and I learned a lot about that on this trip, either by, in like Auschwitz or Treblinka, which I learned was a very efficient factory, but for another time. But I thought about that, and then at that time, the stuff about October 7th happened, and I'm sensitive to this issue, obviously. So, and I was right. I'm just trying to establish that I was right about GTII. I think I was pretty right about that. And then about the same time, I felt a onset of, and I don't call it anti-Semitism, but Jew hatred. I'll call it Jew hatred, that was arising. And I understand, sometimes that happens, historically speaking, when times get tough, small groups are attacked, etc. Happens. So I wasn't surprised, but in my lifetime, I had never experienced it. My parents obviously had. They were deceased, but they had passed. So kind of expecting that and trying to make a point, I made sure not to accept any money, because one of the stereotypes, and I'm just laying it out here, one of the stereotypes that Jews are like all about money. So I made a point, I think I've made it many times without telling you really what the reason was. I decided I wasn't going to accept any money, and I'd incur all costs, and I would be completely, basically charitable, and provide my time to anybody without respect to whatever you believed. And I kind of kept that in the background. So I was motivated by that, and to kind of give you a insight, because this is the issue that I think is the ultimate things. I think the world, unfortunately, prejudges that all Jews are the same. And so I wanted to dispel a particular stereotype, and that's why I have done my things without cost. I mean, without any financial benefit, and incurring all costs. And I'll continue that way from this point in time. But now you know the underlying motivation for that. So, and I will do a travel log, and I'll briefly tell you this. I told you this was the longest introduction in the history. I'll do a travel log for you. We went DC to London, to Krakow, to Warsaw, to Berlin. And while we were in Poland, that's where Auschwitz is located. We went to Auschwitz, and then we went to the Warsaw Ghetto, which is kind of not that, but it was a very interesting trip. I will do a lengthy kind of overview of that for anybody who's interested, who may never get to travel there, who might be interested in the view of someone who has a fairly unique perspective on this. And I'll give you my real thoughts about it. And you might find it interesting. I'll let you know when it's going to be, probably in the next couple of days while it's kind of fresh in my head. But from there, so if I've kind of laid out my motivation, and now I'll bring you. Now we're going to talk about the facts. So I've been bitching at we've been bitching because the concern is we have now moving to GTII. Just somebody who hasn't listened to that intro. We were concerned about the audit, and time has passed, and still no audit. It's not just there's no audit. The last hearing, which was about 2 weeks ago, no, more than 2 weeks ago, about 2.5 weeks ago, as of now, the receiver indicated that there had not been an audit, I guess an engagement letter. So the agreement between, I think the name of the company that he referenced was Integra or something like that, which is a Florida-based accounting firm. And anybody correct me if I'm wrong. And just to remind everybody, it's about 90 days ago when Barton split. Barton was the prior okay, I shouldn't say ineffective because I don't know what they did, but I'm gonna withdraw that comment that they're ineffective. I would say that they didn't complete the audit. That would be a more accurate way. And just to kind of summarize the history of the audit, because I think it's important to understand the history. Originally, prior management, that's the Reichman regime, had Borgers as their auditor. Borgers was suspended by the SEC and basically put out of business. I think the allegations, and again, you can check this to verify if this is accurate. The allegations against Borgers where they were really busy. It sounds like they wanted to make a bunch of money. And so they would take like your 2024 financial statement and change the date to 2025. And that was how they did it. That's an example and kind of facetious, but basically that's what they did. And the SEC found them and they said, wow, that you just can't commit. You can't do that. And they're out of business. So the determination was you couldn't rely upon whatever work product they did. So as a result, GTII had to hire, and this is probably 2023 or 2024, had to hire their own, it would have been 2024, had to hire a replacement firm, which they did, which I think was Fortune CPA, which was located in Orange County, California, to my recollection. And then the receivership came in, and I think the receivership started about August of 2024. I think the order entering the receivership was entered, I think, September of 2024. And so Fortune, and again, I don't remember exact dates, and we're talking about real time, a couple of years ago. That's how long this stupid thing's been going on, by the way. So before August of 2024, before the receivership was established, Fortune was hired by the Reichman crew. Even though I bitched at that time, the receiver elected to keep the Fortune CPA crew on. I indicated that time, and I've indicated, like, if you look back at these boring videos, I didn't understand why, because like from the very start, the receiver seemed to question the activity of the prior management. So I did not understand why, if that was the case, why you would use a auditor that the prior management had selected. I thought that was a bad decision. I communicated that. And again, I'm not trying to take credit for it. I'm just trying to establish that I think I've had a good feel for the accuracy of what's gone on to this point in time. So it's shockingly, he says with sarcasm, about 4 months later, knowing, because in the original order, and again, I'm not quoting the exact language. So when the receiver is appointed and that order is final, let's say September 2024, one of the things it says is like the receiver is going to be immediately take care of basically all the SEC and stuff. And it's going to be immediate. And then there was some early reports that were generated by the receivership, I think, at latest like January of 2025. So again, about 18 months ago, maybe more, suggesting that the audit would be done in 30 days. And in addition to that, and I think it happened twice in that period of time, that's over a year and a half ago. And I know that the receiver had his own forensic expert on. I don't remember the gentleman's name, never met him. I don't know what he does. I don't know how much he's paid. I don't know what his position is. And if I don't understand that, I think his position, again, I don't know what he's doing specifically. I don't know what he's done. So I'm not accusing anybody of anything. But his stated position was something like a forensic accountant that was working on behalf of the receiver. I would think that if we had a forensic accountant acting upon the receiver, that we shouldn't be in our fifth auditor, and that we should be done. I thought that was the purpose of having an expert assist what seemingly are a bunch of experts. And I know that the receiver has spoken very highly of this gentleman. I think he's a gentleman. And I have no reason to doubt that he's expert and terrific. I just surprised that if he was, and if this was his field, that he wouldn't express concerns, the same concerns that I expressed. I don't see why I would have a better feel for it than somebody on the inside. Doesn't make sense to me. But again, I don't know what his involvement is. But if he has been involved, I think we should have been farther along. And again, we don't know how much he's been paid or if he's been paid, which cuts both ways. Because if he has been paid a lot, that's an issue. But if he hasn't been paid a lot, then that's a challenge to why not. And if he's an expert, those fees should be substantial. Not an issue that's been addressed, as far as I know, by the receiver. But now it's out there. And again, I'm filing a brief. We'll be filing a brief, and I'll get to the next issue shortly. But I'm just trying to go through the history of the audit because I think it's helpful to all those new people out there who are watching this today or at some future point in time. So they basically got Fortune wouldn't do whatever they wanted to, or there's some falling out. They fired Fortune, which was the prior management's choice, which I objected to, which they elected to go forward. And all it did was burn a bunch, in my opinion, all it did was burn a bunch of time. They couldn't apparently they couldn't rely upon what was provided. So then they went to Barton CPA, which I think was located in Texas. I do not know. And I don't know. And I kind of also don't understand why they chose Barton. And I don't think that the receiver has indicated reason why he chose Barton. To the contrary, in the proceedings, and he didn't directly say why he didn't choose Barton or why, but he disclosed that the current auditor that he's attempting to hire, which is I think Integra I think it's Boca Raton, and both of those could be wrong. And thanks to Renee for giving me a heads up on the correct spelling of the name, or allegedly the correct spelling. But he indicated during one of these hearings, and again, I don't remember the time difference, but he said like he had been using that firm for over 2 years, and and again, I'm paraphrasing, so he may not have used this exact language, but he did say, to my recollection, it was over 2 years prior, that they had done a great job. He had a great relationship with them, and whatever. He praised this firm, just like he had praised the AI-versity deal, by the way. But he praised and again, all that is my opinion, just like all this stuff. But he praised the company and his relationship, et cetera. And it obviously 2 years would have predated when he chose Barton CPA as the law firm. So I didn't quite understand why, if he was working with this firm that he's now waiting to get a contract with, that he's praised and used before, why he didn't use them instead of Barton. I don't understand the reason. Now, Barton, the problem with Barton, at least many things, and I've bitched about Barton, and I requested that, which was laughed at by the receiver's counsel. In court, the receiver joked about my request to have someone from Barton appear to explain why it was taking so long to have the audit done. And this was probably 4 or 5 months before finally Barton quit. But the receiver's counsel had the audacity of trying to embarrass me in front of Judge Williams. And obviously he was wrong. They were absolutely wrong, or else the we wouldn't be in this position that we were. So I thought it was a bad decision making, and the election to try and embarrass me was kind of a pie in his face, which I haven't really brought to the court's attention, and which will be a relevant issue as we go forward. I wasn't really pleased with that. I never told him, I haven't told him, but now he's aware of that. He's a big fan of these videos. I didn't take kindly to that, and I've never received an apology, and you were completely out of line, and you were incorrect. So I've stated my case, as we like to say. So we have the issue about why not choose the company that he was doing business with and now is not. Doesn't make a lot of sense, and he's never really clarified that. They went to Barton. I don't know who at Barton they contracted with specifically. At a later hearing, I think the managing partner or whatever role testified in court in Las Vegas as to the reason they terminated their engagement with Gtii. I don't believe that was the person who was going to do the work when the receiver contracted with Barton. Now, amongst many things that bothered me about what the receiver did or has said or has not addressed or his counsel's not addressed is if you look through the documents in the engagement documents as to the estimate by Barton to complete the work, and it didn't even include, I don't think it included the most recent year. My recollection, it was on the order of $165,000, et cetera, which is not, I don't think I didn't think that was an unreasonable fee, but we kept on hearing, if you went to court, words like or to the effect that everything was almost done. But my recollection is, despite like an estimate of 165,000, that's a rough number. And I think to do all the work, including the current year, it had been something like $225,000. And if the receivers didn't convey the message that the audit was almost done, then out of somewhere, that was the impression that I got. And I don't think I'm the only one who got that impression. And I don't think that impression was ever dispelled by anyone. So over and over, and we've been in court and we've had a series of status conferences before Judge Williams, the former judge, and we'll address that shortly. But we had a series of status conference or discussions about the audit. And that's up to today's date. So I'm going to stop for a second because that's a lot of stuff. And we're going to go back to some jokes, some more jokes here. So the last, I'm not going to repeat. So my instruction was, those were terrible, shorter and more punch. So it gives me now 4. Pierogi rule. You don't stop eating, you surrender. These are jokes about Poland, by the way, just if you haven't got it. Asked for water in Poland, got water, vodka, and judgment. Poland, more castles than parking spots. And last, this building survived everything. Guide points at the 20th century. And a follow-up to that, I said, give me better jokes about travel in Germany. He gave me 2, and I didn't think these were very good either. So there were 5. So it gives me 5. When I'm telling you is the best of what this new Claude version is giving me. 4, ordered quiet room at a German hostel. Got a lecture on recycling instead. I guess the implication is they're big on recycling in Germany. And Autobahn, no speed limit, infinite judgment if you're in the left lane and slow. All right, I'm going to move back to where we're at. So I was talking about the audit and going back to Barton. So after they had a fire Fortune CPA, long after I'd criticized the move, they hired Barton. For whatever reason, the person they hired either miscalculated the time they would need to complete the audit, or something else. I don't know. Or something happened so that when the person was hired, and perhaps it happened later, I don't know the sequence of events, but whoever they hired ended up not being able to complete the audit before she was leaving due to a pregnancy. I don't know if she knew about it before she started and miscalculated the time. I don't know if the receiver knew about it, knew about her condition and miscalculated the time. I don't know what it was, but in the end, there was some miscalculation about either the length of the job or her availability or something else. So she worked for months, I guess, on the work, and she had to leave, obviously, because she was giving birth. Can't object to that. And they had new people take over. Now, again, I've been bitching about this because I've been bitching about the pace of the audit for 2 years, and I'm not the only one. Obviously, I'm not the only brain surgeon out there. Plenty of people have been bitching about the audit because of all of the because of the length of time that has gone on. So I was bitching about the audit, and then the prior auditor left, and they kind of put something out, and then there were new auditors from the same company, but it appeared, and this is my recollection, somebody could correct me if I'm wrong, and certainly if you have a different recollection, please let me know. They indicated that the new auditors, for some reason, couldn't rely upon the work product that the prior auditor had done over the various months and kind of had to start anew. That was my recollection. Something like that, words to that effect. They couldn't just kind of move on. They had to kind of go backwards and then start again. I would think, by the way, that would require some adjustment in price, maybe, I don't know, up or down, plus or minus, but you have to have, as opposed to one person doing the audit, now you're having 3. I would think that would impact the cost of the audit. So that might make the audit more expensive, especially if the contract, and I didn't read the contract, but maybe the contract has a provision if like unforeseen circumstances exist and we have to bring in a new auditor, then we are able to charge you for that. I don't know. I didn't see the contract, and I'm not blaming that auditor. Obviously, I'm blaming that there was some miscalculation which caused a delay. After the delay caused by choosing or staying with an auditor that obviously shouldn't have been chosen because the receiver fired them anyway, without explanation why the receiver didn't choose the parent auditor or future auditor today, who they already had a good relationship with, according to the way I heard his testimony. So now we're way down the road. These new auditors come in. We're still bitching because there's a general, if I post anything, there's some people will bitch about the status and that they said this before and they knew it all, etc. Happy they're, participating. It's good that everybody gets channeled to kind of unleash the pissed offedness that they get with this thing. So new auditors come in. We don't see any I don't remember any kind of change of contract. And also, apparently, they probably should have filed, according to Claude, when they changed auditors, or Claude couldn't find it. They should have filed like an 8F when they went to Barton, but it appears they didn't file an 8F. They should have done it. So that's probably a deficiency in the filings. Perhaps Claude is inaccurate and they just couldn't find it. But they did a public, the way they say it, they do a public record search of all the filings. They couldn't find that filing. And they concluded that there should have been a filing of the hiring of Barton after the firing of the prior company. But I don't know that for a fact, and I don't know if there was a filing, but that's what Claude said. And, we all know Claude. Claude makes mistakes sometimes, so maybe he did here too. But then we get the new auditors. It's taking forever. Everybody's getting pissed off. It's taking too long, just like this video. And eventually, we come in, they start doing monthly status conferences, probably starting the end of 2025. Every month we're coming into court and we're finding out what's going on with the audit, what's going on with the audit. They're each month, literally each month, not the receiver doesn't necessarily testify each month, but it appears that's communicated. He doesn't want to specifically abide by a specific date because he's asked about that frequently, about a specific date. I can't accuse him of saying that he promised it by X date because he didn't, but he gave the impression, not because I participated in all these stupid hearings, that it was imminent or it's soon or certainly less than 30 days many times. Without him saying 30 days, the impression was it was less than 30 days. And sometimes the terminology was imminent. And before imminent happened, the firm that I didn't know, again, in retrospect, why he chose, because doesn't make sense in the context of the events as described by the receiver, as I understand. Eventually, Barton quits. The two auditors who came in for the first auditor apparently come to an end. There's a bunch of transactions that they can't get, for whatever reason, because I went to the hearing and I did not understand. I don't think it was clearly presented why they couldn't complete the audit. Perhaps it was clearly presented. Perhaps I'm just too dumb to understand, which is very possible. My kids certainly tell me that frequently, but I just didn't get it. Didn't make sense to me. And I would think if you were at an expert level, you would be able to at least make determinations if there wasn't. So I think the issue was substantiation of transactions. I would think if you can't substantiate your transactions, you'd be able to treat the transaction in a different manner. I don't know that for a fact, but I'm concluding like that's kind of life in the big city. It's one way or the other. It's either good or bad. And I don't think it was explained why they couldn't even draw a negative inference from a non-documented transaction. Also, it was hard to tell what the amount was, the materiality of that. And again, I would think like an expert should have been able to do that. Now, ironically, as portrayed by the current receiver, he referenced that this company, I think it's again Integra and Boca Raton, and again I could be wrong, that he indicated 90 days ago had said they could complete the entirety like in 120 days, including the most recent year's financials. Again, I don't quite understand why he didn't, but he at hearing said that I think it's about 90 days, and now 90 days have passed approximately. We still don't have a contract. Doesn't make a lot of sense, honestly. So a lot of people bitched about the length of time of that we had gone through. We're now like in a dead period because we don't even have a signed contract. There was a prior indication, and during one of the hearings, the receiver said, when asked about the financial condition of GTII, that there was less than $10,000 in the bank. My understanding, and again, I don't know this for a fact, so this is kind of, you could treat this as speculation, but I've mentioned this before, that I was told, I think by counsel, it's my recollection, in or about November 1 of 2025, that the firm that's doing the litigation or representing the receiver had been paid in excess of $500,000. My impression, I don't have a direct understanding, but my impression is that they're owed as of, I don't think they've been paid, or at least as far as I know, I don't think they've been paid since. And we are now like 8 months out. And I think they did a bunch of depositions. If you notice the pace of the depositions, and I'm going to address that coming up also, the pace of the depositions kind of slowed down. But there was a period of time where they were really active, and the docket is quite long. So I had a discussion with another attorney who works in Nevada, and he made some reference to the docket kind of jokingly about it being particularly long, and that our discussion, I saved him a couple of hours of going through everything. But anyway, it kind of brings us. Nothing has been. There's no contract. We're kind of waiting. Then about June 30th, so that's 4 days ago, I'm on the service list, which means like I get notice of anything that's filed by any other party or by the court. So I get it and I could look at it. So I got a notice, and the notice changed the date. So we're supposed to have a status conference. It changed the date of the status conference, the next one, from August 5th to August 6th, but it also was in a different department. And from another source, I confirmed that the judge had changed. And so before we had Judge Williams, and Judge Williams was a judge in, this is my understanding. I don't know if it's accurate, but it's a viable story. So I'm going to assume it's accurate. And if it turns out to be inaccurate, then so be it. But there's a presiding judge of the court. So that's a judge who oversees the operations of the court, makes the general big decisions. My understanding is apparently in Las Vegas, in the Superior Court, in the state system, that most people believe that the most competent judges are in the business courts. And I think in Las Vegas, in that central high rise, there were 5 business court judges. Judge Williams was one of the judges. And apparently a lot of people may try to be getting the best judges. So they might mischaracterize their case to get amongst those judges. I think the filing fees were higher. So it might be a way of kind of directing, kind of like judge shopping. So apparently, and again, nobody's told me this specifically, but certainly the presiding judge hasn't told me. I don't know who the presiding judge is, but the presiding judge is trying to prevent judge shopping. So they reduced the business courts, and I don't really understand the logic of this, by the way, but they reduced the number of business courts from 5, let's say, to 2. And so as a result, Judge Williams is no longer in the business court judge, and we have a new judge, and that's Judge Hardy. And now he will be in Department 15. So he's taking over the case. So what have I heard about Judge Hardy? I think I've heard that he's, is equally as capable as Judge Williams. He may have a different style, and he may have a different style in court also. He's one of 2 judges, so I think they will have a lot of cases. I don't know how that's going to affect how they deal with cases. The person I spoke said, and they were just kind of, they didn't know for a fact, but we were talking about the receiver and the receivership and issues about the receivership. And I was asking about, how would you get rid of, just kind of like generally, just, this is kind of like a discussion. How would you be able to, if you were kind of to judge how the judges would react to a receiver, how would you view that? And my impression of this, and it's not specific, my impression is because Judge Williams appointed the receiver and was very, by the book, calculated, thorough, reflective, very reflective. Sometimes he would get a, motion. He would reflect on it for a while, and then an order might come out substantially later. I believe, and at least I've heard, that Judge Hardy may be more immediate, but I certainly have no experience about that. But because also he's a reflective and thoughtful guy, I'm now referring to Judge Williams, if he okayed like the presence of a receiver, it would take a lot and a very detailed process to take any activity with regard to changing that status. And I kind of understood that. It makes sense. And that was kind of consistent with the Judge Williams handling of this matter. Just to be honest, I wish he had been more harsh with the receiver, or required more of the receiver. I filed multiple briefs, and I tried to be respectful to the court, and still am. I appreciate his handling of the case, and I can imagine how difficult and how much time it takes to handle a case like this. And he's handling lots of cases, so I do appreciate that. He's certainly a very competent judge. But on the flip side, and if I was going to offer a critique, I filed multiple briefs, and he only acknowledged one of my briefs on the last hearing, by the way, his last hearing in this case. He specifically referenced to my brief, and I was able to address it. So that's my one critique. I thought he was super competent, a smart guy. Wish he had been harder on the receiver. Now we have a new judge, and perhaps the new judge, because the new judge wasn't responsible, didn't sign off on the receiver, and perhaps he would or he wouldn't. I don't know. We don't know. It's pure speculation. But I would think that because he's not, like, in a sense, married to the receiver, that he might be more interested in the concerns that we all have about the receiver. And again, if I was going to point out two things, not to make it as complicated as I can, two things. Where's the audit? Two, where's any transaction? That's bang, bang. I would just start with that. And I don't think you have to go much farther. And that's been, again, if you look at the original order, and I asked Claude that at some point in time. That's basically the single most obligation that he has that would benefit shareholders. And that's the only thing that has not been, well, okay, I shouldn't say not the only thing. There may be other things that haven't been completed, but that's the one certainly big thing that we all have been waiting for that's not completed. By the way, when I asked Claude, and I'll get back to the judge, when I asked Claude about what hadn't been filed, and I asked a couple of times, and I don't know if this is accurate, but I know there's obviously missing filings. It's about 9 periodic reports, plus the one I mentioned about the 8K when Barton took over. They said there also should have been 1 or something to that effect. So that might make 10. Maybe there's more, and I don't even know if that's accurate, but that's one of my choices of using Claude, again, of Anthropic, and I'm no spokesperson from Anthropic. And by the way, it's another thing I don't do. I would never have any sponsors, by the way. I wouldn't want to do that either. Just free content, free, exciting content, and terrible jokes so far from Claude. Thanks to Claude. So we have new Judge Hardy. And the first hearing is August 6th, which changed from August 5th. It's supposed to be a status conference. I'm sure the issue of the audit will come up. I do not know. I will certainly be involved in the hearing. I will be filing a brief, certainly, also on the hearing. It's very possible there may be other filings that occur prior to that time. I would not be surprised, and I wouldn't necessarily expect those filings to be from the receiver. So we shall wait and see, but that's kind of a potential expectation I have. We'll leave it at that. But I will certainly be filing a brief, and I'm going to, as opposed to the prior briefs that I filed. And by the way, whoever is out there, hi, happy 4th. Hope everybody's doing well. Thanks for hanging here this afternoon. Hope everybody's safe. Hope the weather is great wherever you are. When I was in Europe, by the way, just as a side issue, it was blazing hot. In London, it was for Londoners, it was like 95. And the one thing that we take for granted in the United States, although I've seen some memes while the World Cup was here, air conditioning. Europe does not have air conditioning, and I think the chief reason is their grids. This is at least what I heard. We have problems with our grids. You ain't seen nothing yet. Apparently, their grids would not support air conditioning for all their citizens, and we would not tolerate that. I think while I was there in France, for example, I think during a stretch of time, like 1,000 people died from heat. Can you imagine tolerating that as a country? Absurd. But apparently no air conditioning due to a lack of a grid, which kind of shocked me that was the reason. I get what happened to solar, they certainly solar power. I know Germany used to have nuclear power. They got rid of it. They got stuck. This is not a political message. This is true. Germany moved away from nuclear power, whether you like it or not. but they didn't like embrace or have a plan to replace it. So there's a period of time they were without. During that time, the Russians stopped shipping oil. They were without oil and stuck. So not great planning. And I think that was done by the prior Prime Minister Merkel. A bad choice. I discussed it with somebody in Germany, and they mentioned that also to verify it. So we're going to be in front of Judge Hardy, back to the courthouse. We're going to be in front of Judge Hardy on August 5th. I will be filing a detailed brief. And so I was mentioning that. My brief will be different than the prior brief because my prior brief kind of just went on from the so might have been the 6th brief I filed. So am I going to bother the judge by repeating everything I said in the prior briefs? No, I would just kind of pick up from where I left off. This one, I'm probably going to be a little more detailed. For example, the discussion I just kind of gone through about the auditor and the history and the sequence that I think's kind of on the record, and I don't think the receiver would disagree. They may have different reasons, but in terms of the sequence, I don't think they would disagree with the sequence that I've described. I think the new judge will be very interested, and I don't know what, maybe he won't. Maybe he'll think there's nothing there. That's very possible. But it's also possible he might be very compelled and inquire further, put more pressure to get things done, get an explanation why it's taken so long to get even an engagement letter from somebody that the auditor, to my recollection, said he had a great relationship with, had done fantastic work, was continuing to work with them, but he didn't choose to do our work. So I kind of wouldn't understand that. So as a result, I'm going to reflect a lot of that and hopefully not too much sarcasm in the brief. And I'm going to try to be more detailed. So I know that the Receivers Council watches this, so that's what they can expect. And if, they have perfectly legitimate explanations, I certainly would love to see them. And perhaps there is, there may be explanations, but it's uncomfortable that we're 2 years out and we still haven't got the audit. So the way I see it, there's only two real reasons we are almost 2 years out without an audit, despite the immediate reflection in the order to get it done. And maybe there's other reasons. Actually, there's probably 3 reasons. I would say the most likely reason, and again, this is just my opinion, having reviewed the record and where we are today, I would say the audit has been incompetently managed and handled. Because I think if it was competently handled, we would have completed it. Better selections would have been made. Alternative selections were made. I think to date, all the selections that have been made were bad selections. And I don't think anybody can argue that. So if you judge management by decision-making, I would say as to the audit, management, which is now the receiver, would be at best has grossly failed. The second most likely alternative, and this is just my opinion, that there was an intent, and I would assume that I'm going to give the auditor, I'm going to give the receiver the benefit of the doubt that he just incompetently managed the audit process, because that's my conclusion and my opinion. But I guess there's another alternative, and I know there's a whole class of people that believe this because I see it on response to when I post things and I hear it and I understand it. I understand why they believe it. I'm still a skeptic, but I understand it. And the longer we go and the more the onion gets peeled back, the more I can understand why people feel it more, even if it doesn't turn out to be. But some people believe it's intentional. There's various speculation as to why it would be intentional. What benefit could the receiver get? This is the speculation. And again, I don't believe this. I believe just that, and just my opinion, that it's just been incompetently managed. And it's just my opinion. I don't know if that's true. I don't even know what the standard of care is. It's my opinion from watching where we've gone and their decision making. And I'm judging it specifically by decision making. But other people believe that it was intentionally done. And again, why would it be intentionally done? I have a difficult time understanding it, except for stuff that came out in the end, kind of the most recent stuff that came out. And then we heard about the DTCC and about Alpine. And, there's been a discussion about Alpine and the short position and the concentrated short position. To those you don't know, Alpine Securities has been involved in a lot of litigation with the SEC, the DTCC. At some point in time, I think one of their employees, they tried to get to be like a representative in some fashion of their company. And I believe the gentleman, according to the public record, was a convicted sex offender who tried, literally, I think the record said, that he was in a movie theater next to a father and his underage daughter, and he was trying to grope the daughter. He did it multiple times. Daughter became uncomfortable, scooched away, and then the father encountered him as he was trying to flee the movie theater. And I think he was arrested. I think there was some plea deal worked out, but it was public record because it was in a DTCC ruling, and that was who Alpine Securities wanted to be their a front person for them at some point in time. I think he had a legal background. I don't remember specifically what his role, but it was to be some kind of representative capacity. DTCC was excluded him, and they were trying to get it to overturn the decision, and they lost. It was either the SEC or DTCC, but there was a long opinion that was involved, and I saw that. Also, one of those opinions, there was a reference by the DTCC that Alpine Securities, that same company, had a concentrated short position in GTII, which basically meant that they were a risk to the system because they were way too leveraged, and they didn't have enough cash to cover that position, and they got in trouble for that. They certainly disagreed with the allegations, but as a result, they've been targeted for all kinds of things. They appear to work with shorts. And so a lot of people believe there were shenanigans that went on, but there wasn't really concrete evidence. But then the DTCC talked about Alpine having concentrated short position. That kind of died. Everybody was wondering, where was the SEC? What are they doing? What has happened? I know I reached out to the SEC multiple times myself, but everybody's wondering what was going on. So time has passed, and it appears maybe that somebody actually is looking at that stuff. Somebody's maybe looking at, and this is just my speculation. Perhaps somebody is looking at trading information, habits, etc., and we will see where that goes. It seems like maybe the SEC should have, in my opinion, should have been involved long time before that to save the shareholders in this matter. I would think hard for me to believe if the SEC or whoever, and I'm going to get back to the DCCC stuff in a second, hard for me to understand if the SEC or the DCCC has supervision responsibilities over companies and does occasional audits, how this could be missed. How, did they not do the audits? Were they not required? If they did them, were the people incompetent? Remember, just to kind of add a little flavor to this, which also might make you think when you're thinking about intention, the guy that we focus most of our attention on, who has not settled, by the way, as you note. Remember, there was a discussion that the counsel for the receiver was trying to settle with the top management, but that hasn't occurred. And they haven't asked for an extension, which is curious in my fashion, in my view. But he was an expert. He was a tax expert. I think he ran a CPA firm. So, this shouldn't have been like a shock to him. And I think the receiver accused him of engaging in all kinds of conduct, sending him all kinds of entities, which appear to be kind of used to disguise transactions. Or, that was the kind of suggestion that they were used to make following the money really difficult. And I think that was one of the reasons given by some of the accounting, and I don't remember if it was specifically given or was suggested, but some of the accounting auditors who have been engaged, I think they referenced that part of the problem was just tracking some of the transactions, and they may go through all kinds of hands and entities, and that was difficult. Perhaps it was difficult. Perhaps the receiver underestimated, perhaps the receiver should have chosen a bigger firm to do this that was capable of doing this in a quick amount of time, notwithstanding the cost. I don't know. I don't think that was and again, just my opinion, the original amount, and I think I told you at some point in time that the receiver in like the 90 days ago said there was like $10,000 left in the bank accounts. But at some point in time, I think there was about $1.5 million cash available, maybe over a period of time. I can't imagine we couldn't have hired an auditor, paid them full bore, and get it done in a short period of time. It probably would have been a bigger firm more qualified. Perhaps they would have billed more money for it, perhaps. And I'm going to get back to DTCC and Alpine in a second. But I'm going to take a quick break, head back to jokes for a second. I think so. I'm just going through Claude again. This is recapping. This is Claude Anthropic. I ask him a series of questions, he or she, whatever it is, to give me jokes, and I keep on giving him instructions after he gives me jokes if they're good or bad. And we're kind of going through it, or travel-related jokes related to the places I visited. That's kind of the theme for today. Give me better jokes about travel in Germany. I think I said this one. So we'll go to the next one. Give me some actual really funny jokes about Germany. German efficiency. And if you know German, this will actually make you laugh. They invented a 40-letter word so they never have to say 2 sentences. Yeah, and that's part about Germany. In German, the words are really long. And so that was 5 jokes. That was the only one I could use. Do better with German jokes. So here's 4. Germany is the only country where the pedestrian light is a suggestion for tourists and a religion for locals. German bureaucracy. You need an appointment to make an appointment, and both are booked out to March. In Germany, Ruhezeit means quieter hours, which somehow includes a stranger yelling at you for using a drill on a Sunday. And last but not least, German recycle so intensely there are 5 bins, and you still will be publicly shamed for using the wrong one. And I'm going to leave that at there. I think we will have one round of final jokes that we will get to before the end. So now I'm back. We're talking about DTCC. So they've referenced Alpine as having concentrated short position, but nothing happened. When I initially addressed it to the counsel for plaintiffs, so when the receivership was started, I brought it up. They kind of poo-pooed it. The issue, I don't think they also understood the issue, because all of us who have lived and died with either MMTLP or DTC or GTII or the handful of other companies that have been shorted endlessly into death, literally to death, sometimes even biotechs that might have been health companies that might have provided alternative solutions to health problems. So when I say to the death, it may have been actually to the death. But we all have been, at least some point in time, in these companies that have been shorted to death. And we've suspected, and probably justifiably, that there were shenanigans going on. And so, but there hadn't been any movement. The Receivers Council poo-pooed this also. I presented to them long ago. They didn't think there was anything to it. And I don't know when that changed, but at some point in time, it changed. They got documents, and it turned out that, and I guess at that point in time, it was Alpine Securities who was responsive, at least that's my understanding, and that's what counsel for the receiver mentioned, that Alpine was responsive to their document requests and had cooperated. On the other hand, the DTCC was not, and they weren't being cooperative. As a result, there was another hearing, and I think there was a filing, and basically the receiver asked for some kind of order from the court, for the court to say that the court has a jurisdiction, in other words, can enforce an order to compel compliance by the DTCC, and that the receiver could seek documents and depositions from all these people. So there was a discussion about that. I think there may have been an attempt, but something happened with the attempt. Now that coincides with the time where I mentioned previously where the receiver referenced, and I think again it was 10 grand, but he referenced there was less than 10 grand in the kitty. And this was in response to a question by the court. This would have been Judge Williams about how much money was there to pay for the audit that we haven't got a contract on as of today. He referenced less than 10,000, which kind of drew a surprise gasp by the people at home. But after that, he was asked, he suggested, without being clear, I didn't think it was clear, but it was a clearly suggestion that somehow he, or more appropriately, GTIR, the receivership, could somehow borrow money. I don't know against what. I don't know where, but they could borrow money to pay for the audit. Now, I don't know if that's true or not. I don't know if it's happened. If to get the audit done or get the audit started, they required cash, and they thought they were going to be able to get money to pay for that, and they now can't. That might explain why there's no contract been signed. I don't know if that's the case, but I'm just kind of speculating out loud. Pure speculation, because I don't know what the arrangement is between the receiver and I think it's Integra, or some version of that name, proposed auditor. I don't know what they're charging. But if in fact they do have the funds and they kind of locked up the funds, then I don't understand why there's a contract. Now, on the other hand, if in fact the attorneys for the receiver are owed, hundreds of thousands of dollars in legal fees, which I'm guessing they are, just guessing, I don't know that for a fact, it generally would kind of produce a slowdown in doing work, kind of like two alternatives, kind of historically speaking. You could just kind of slow down the work. There could be some agreement. And again, I don't know if these are true. I'm just kind of telling you my experience when the relationship between the client and the attorneys kind of worsen because of a bill that is owed. Generally, what will happen is there could be some agreement. Well, I guess you could have a lot of things going to happen. One, the attorneys, without consulting the client, could kind of slow down the pace and justify that, and it'd be hard to prove otherwise. Two, there could be some understanding that kind of, you owe us a lot of money, so let's kind of chill for a while, and there could be some agreement like that. Three, the attorneys could just quit. They could ask to be released out of the case, and I'm referring now to California, how it would work. I don't know how it would work in Vegas. I assume it's very similar. You could ask your client to release you out. You owe me a bunch of money, or alternatively, if they say no, or you're in bad terms, because usually when what happens is the most important or most common reason that the attorney-client relationship will break is because the money is owed from the client to the attorney. And if the attorneys don't get paid, they get pissed and they stop working. They can't ethically stop working unilaterally because there's an obligation to represent your client as long as you're involved. But, you could work out an arrangement, or there may be ways of kind of disguising it, or you can literally, again, ask your client to release you, or you file a motion to be relieved. And, almost always, if you file the motion, you'll be relieved. The only times when it wouldn't be that case, or generally, is if it somehow would prejudice your client substantially. And that's usually if you're really close to a trial. And what's close to a trial? I would say minimum, at least 90 days out. So let's say if you're within 90 days of a trial date, you probably are stuck through the trial. So most attorneys, they will not usually wait. And obviously I've had to file motions most times because the client disappeared. I'm usually not representing IBM also, or, Apple Computer. That's not my client. So I usually represent smaller businesses, etc. But anyway, so that's the process, how it goes. But I would expect, counsel, if they were not happy, that either they're going to get paid or they're going to stop working and they're going to try to get out of the case. I don't know if that's what their intention is. I did ask them specifically if they were still in the case, and Dylan Siciliano said to the effect, "You still see me in the words to the effect, you still see me in the," and I thought there was a little bit of sarcasm attached to the words he used. Perhaps that's me reading into it more. His response was to the effect, "Well, you still see me in the courtroom." That I took that to mean that he's still in on the case. But I would think at some point in time, if they continue not to get paid, that they will be out. And what I thought was interesting to me was that for months they've been indicating they've been negotiating with Reichman about settling, and that might also include his daughter. And just to bring everybody up to speed, that early on I suggested to them, to the Receivers Council, and for whatever reason they elected not to do it. I still think it was again my opinion, just my opinion, being a California lawyer who does real estate litigation or has in the past. I didn't understand why they didn't pursue an action against the daughter in California if the receiver believed that the source of money to buy her home was through the sale of GTII stock, which I think was the position. I never understood why they didn't pursue that. I represented that. I requested that long ago. I mean, sure, over a year ago by now, well over a year ago. Never made any sense. And I also thought if they were being aggressive, that they could file a Liz pendants, which kind of locks up the property, because they have obviously they have an arguable claim against real property. And in my experience, I've seen a lot less that would justify filing a Liz pendants. And what a Liz pendants does means that if you were trying to sell your property before escrow would close, somebody would look at title and they would see this and they'd be scared away. So you couldn't sell you couldn't sell the property. So I didn't understand why the attorneys did not pursue that. I think it was, in my opinion, a gross mistake. Just my opinion, being a California attorney. I believe they all have licenses in California. That's an opinion. That would be my opinion. I certainly, the risk when you file a Liz pendants, if it's over, and you would have what would happen is before you would be liable for fees, there would be a motion. Somebody could file a motion to expunge a Liz pendants, which means they can go into court. They could file a motion with the court. They could say this lawsuit does not affect Title II or the right to possession in real property. That's kind of like the standard in California. And if you prove that up and let's say you own the property and now there's a Liz pendants on it, so you can't sell it, you can't borrow against it. So you challenge that Liz pendants in court. And if you prove that it doesn't affect Title II or a right to possession in real property and you win, then you may be entitled to your legal fees. Just for that motion, not for the whole case, but just for that motion. So that could be some amount of money, not a significant amount of money, not like $500,000 that the receiver was paid according to, and I think just to be fair, I think I was told approximately $500,000. I guess it could have been more, could have been slightly less. And again, that's November, very beginning of November of 2025. But again, I didn't understand why it wasn't filed. I thought it was a bad strategy all along. And I represented that to them. And I represented it to the plaintiff's counsel also, because I thought it would put pressure on everybody. Thought it would be, and I thought everybody knew, and I had thought this was common knowledge, that everybody thought that the gentleman who ran this company, who didn't appear to do a very great job for shareholders, that his only weak spot was his daughter, and apparently his daughter had benefited, according to the receiver, and apparently how it sounds, had benefited from the sale of shares that she probably shouldn't have had, according to the receiver. If that's being the case, that property should have been come back to the receivership. For whatever reason, they never challenged it. I thought it was a bad move. I think it was as of today, I still think it was a bad move, miscalculation. I didn't understand why it was done, especially if they could litigate in California. And again, the only risk is that you might be liable for legal fees, but it wouldn't be how much could that be? Could it be 25 grand? Yeah, I doubt it, but it could be theoretically. But after a motion's filed, you always, almost always, if you have any kind of, if you have an experienced practitioner, so if somebody files a motion to expunge and I go to them after seeing it and I decide that they have merit to what they're saying. So maybe my lawsuit can stay and it's proper, that there was some shenanigans going on and you owe me this money. But maybe it doesn't affect Title II or right possession of property. I think the allegation was that there's like a step. So there's the stock sale and then money is used. And so there was a disc. I didn't quite understand. I think it was didn't think it was made a lot of sense as a kind of analysis. But always thought that was the proper way of doing it. They still haven't done it. So now we get to today, where they kept on extending the time, and because there's cutoff dates, and they have to apparently at some point in time, because everybody else I think has either been done or else there's going to be some future litigation because people have claims. But as to David Reichman, I think that was the one they referenced specifically. They had indicated multiple times they were involved in negotiations, but we need to extend the time to finish it. And we've looked at, both have documents, we've looked at it. And as far as I know, like every other one, it was subject to court review and approval, and it was going to be open process. And I haven't seen anything to believe that any deal between the receivership and the senior management, Reichman, et cetera, has been done. So up until this kind of gets back to why has there been a lull? And before I get to the final part of this long, drawn out video, the bottom line is that it hasn't been, the accounting still remains, and we move on to, I'm shifting. I wanted to shift focus away. I don't want this to be 4 hours long. Let's just talk about the discovery. So I've been asking for discovery. I thought I was going too long, so I wanted to shift away. I've been asking for discovery, and they referred to DCCC and also to Alpine Securities. They originally expressed an interest in going forward. I thought, I'm kind of headed back in that other direction a little bit. I thought the reason why things slowed down is because the money slowed down, and I wondered why they hadn't continued on with the negotiations with Reichman. And as it turned out, the last extension was June 30th. As far as I've seen, I haven't seen any further extension filed by the parties, and there's no extension. So it appears that they have not entered into an agreement with Reichman, a settlement agreement. Appears, according to the facts, and they haven't filed an extension, which means money that they might have been expecting by the sale of either the Reichman property or refinance, because there was an appraisal done at one point in time, and they asked for money, a small amount of money, of Reichman's money, to be released to do an appraisal. I don't know if it was on both properties, by the way. He has a property in Westwood, I believe. His daughter has a property in Northern California, Marin County, I believe, a very, very high-end area. But they weren't clear what it was going to be used for, but it suggested that it was going to be used for figuring out how much the property was sold, either, and the only two alternative kind of choices I would think, to sell the properties and generate a bunch of cash, or to borrow against them to generate a bunch of cash. Since there hasn't been an agreement, whatever cash that the estate might have been expecting might have come in from those sources, may not be coming in. That might explain kind of a slowdown in legal proceedings. So I've been bitching recently about what happened to discovery about Alpine and et cetera, and DTCC, et cetera. And I sent out numerous emails to Dylan. I kind of talked about him multiple occasions, had not gotten any response. And then recently I saw July 2nd, so it's very recent, just received a document called Notice of Intent to Serve Subpoenas. Now, maybe Dylan, because he's this, it's both William Knoll and Dylan Siciliano, but it's the electronic signature of Dylan. Perhaps, the money issues are not relevant. Perhaps me bitching about this for the past month didn't have any influence. Perhaps it just took time, whatever. I don't know, but it is what it is. Dated July 2nd, notice of intent. And then, I think prior subpoenas were served, and then it appeared to me again a drop in time where nothing occurred with no explanation, including, by the way, before I get on to it, the last hearing when there was a hearing where the receiver was on Zoom. The only people that spoke were William Noel, because Dylan Siciliano elected not to speak. I think he was at some kind of conference. He might have, I think that was the one. And he was there appearing on behalf of some other matter, elected not to speak on this matter. William Noel spoke. I thought it was a weak presentation, to be honest. I didn't understand his explanation for the lack of a contract of engagement with that auditing firm, Integra. Didn't make a lot of sense, and I wasn't the only one who concluded that. I just didn't think it wasn't clear, wasn't a good presentation of him being critical. And I don't know why Mr. Siciliano didn't handle it. But what was more interesting is, so they're coming back after having recommended this firm and suggesting they can get it done quickly, and they had a great relationship, and they don't have a contract. And I think he stated his appearance. I don't even know if it was the case. I know he appeared. I don't know if his attorney appeared on and stated his appearance, or if he spoke. I'm not sure he even spoke to announce his appearance. So when you go to court, everybody who's appearing in the matter has to announce their appearance. Richard Hoffman, plaintiff and pro se, means I'm representing myself, for example. That's how you would say it. I don't know if he said it or his counsel said, and the receiver is here also. I don't remember. So I don't know if the receiver spoke at all. But after Mr. Noel indicated with some unintelligible manner why there was no contract after what was professed in the past, without explanation, why this so-called amazing, in my terminology, auditor had not been chosen before Barton in light of the timing that the receiver seemed to suggest, the receiver didn't speak. So he didn't clarify why there was no contract. It was obvious. His absence, his failure to kind of explain it obviously it was an embarrassing situation, clearly embarrassing, because he's one hand, again, this is all my opinion, but on one hand, he's kind of promoting these guys, says it's like, he's my best friend, and you go up to him and the guy doesn't know you. These guys are great. They're fantastic. They're on top of it. We've done work with them for a long time, 2 years. They'll certainly, act quickly. They said they complete this within 120 days, which suggests there's been communication. And yet 90 days later, 60 days later, too long, after the long string of events, no contract. We haven't seen a filing. Maybe it's out today. Maybe in honor of the 4th of July. It's going to be out. But I know for sure if we don't bitch about this, the way this has gone, it seems like if we don't bitch about this, it ain't going to get done, because these guys do not, at their own pace, I will certainly be dead and gone long before this is over. And they've made it so without staying on top of them and being obnoxious by kind of staying on top of them, without, certainly justified. This is not unjustified criticism. It is what it is. I think if anybody examines the record, they're going to come to the same conclusion. I don't even think the Receivers Council would disagree with what I'm saying, honestly. I haven't accused them. I understand their job, and I feel bad in part for their position where they might feel stuck. They may really feel stuck in this case. I'm sure, in retrospect, I don't know what their opinion is about the receiver at this point in time. They might even be more pissed about the receiver and how they've managed the audit. It's been represented. The receiver has been having the most direct connection with the auditor. And I'm going to add one more point just to kind of fill that out before I go to the subpoenas. Also, throw this in the picture. The receiver has represented that he had an expert involved. So you throw that in, an expert forensic accountant. So on top of everything else, without explanation, having an expert accountant involved, forensic accountant apparently, who we don't know how much has been paid, we don't know his role. We're still in this position. Unbelievable. Makes no sense. You know, why would somebody be suspicious 2 years out if literally the most important things for the retail shareholders are an audit being done and some transaction being done, and neither have been done? So why wouldn't shareholders be suspicious? And less than transparent, go look at the at GTII receiver site on Twitter. At some point in time, the receiver certainly gave the impression that there was going to be regular communication. He certainly gave the indication that there was going to be regular postings on Twitter, marked X as of current. Go take a look and see how thorough he's been in terms of communicating information to us shareholders about all kinds of details. I don't find him to be, and you know, it's also somebody who starts with that they're being transparent. In my opinion, that's an issue. So, you know, if somebody talks about something, that's only because that's an issue with them. And I would say that the issue, or one of the substantial issues here, if you look at the Twitter account, is transparency or lack thereof. And even in court, I found the receiver to be obtuse. And maybe he's just inexperienced. You know, I've heard representations that the receiver this is his first receivership, and maybe it's just that he doesn't know what he's doing. I mean, if he doesn't know what he's doing, you know, in other words, maybe some tasks he knows because of experience, but in terms of the overall management of a receivership, he doesn't have experience with that. So he's learning, and maybe that's why he took the deal he took. Sometimes you would hope that his counsel would be able to kind of direct him so that he would operate in a more realistic and practical fashion. Perhaps they are. Perhaps that's their view. I don't know. But it seems like to me that he's not been overly transparent, in my opinion. And it appears to me that he's being extremely cautious. Not that that's his standard, perhaps it is, but out of a lack of experience. And I could be wrong. It's my impression. I just don't think he has a lot of experience, or he's acting to me like he doesn't have a lot of experience in receiverships. And part of that, again, is, to me, all the missteps, in my opinion, as to the audit. And I think it's hard to argue with that. So jumping back to the subpoenas. So I recently, and I sent a bunch of emails that were not responded to, and I think I speculated. In the past, they've indicated that the Receiverships Council has indicated that if it's not public information, they're concerned it might impact trading. I don't know who's trading the stock. I know I can't trade the stock. I don't know who can trade the stock. It's an expert market. Maybe there's a few people, but I certainly can't, nor would I, because I made that pledge too, that I would not trade the stock till everybody could trade the stock. I didn't want to be besides insider trading, you know, maybe because I'm sticking my nose in here. Maybe I know more than others. So maybe I'm, but I certainly would not trade on that kind of information, nor would I take any preference over any other shareholder here, because that's our joint goal, to somehow get out of this nonsense, to somehow get liquidity out of this nonsense. And I did see, by the way, and again, just kind of throwing it out, I did see a post by Forster, and he indicated something. I don't know anything. He indicated to me that he was proposing some type of exchange, but it was very unclear, and it wasn't. At this point in time, I don't know what it is, other than the amount I just described. And I don't know how it would happen, and I don't know how it would occur since we can't trade it. But perhaps at some future point in time, he will clarify that, and will certainly when he does, and I understand it, I'll let you all know. But he did post something on X about his future intentions, so I put it out there. I also believe there's other activities that are going on in the background too. I don't know before we get to the end. I don't know, again, as of today, just to be honest, I don't know the receiver's true intentions. I don't know if his intentions are to be able to trade this stock or be able to liquidate his stock like everybody else, or if he thinks that a bunch of additional cash is going to come in and he's going to be done with it and the company is going to be BK and that's it, or else there's other alternative ways he's getting compensated. I don't know, and I don't know him, and I don't know if his attorneys know him, to be honest. So I'm not accusing him of anything. I just don't know what his true intentions are. I know he's, again, in my mind, he's not been transparent, so I don't really trust him. And that's why one of the reasons I keep on staying on top of him. But that doesn't mean that he's not well-intended and he's not operating in good faith. I don't know that. I just kind of, my interactions with him have been unpleasant, and I don't think he's been transparent. And I know where the audit stands, so I'm skeptical. And I know a lot of people have been skeptical, and I kind of let the facts play out, and that's kind of where we are. So I don't, in light of the fact I don't know what his intentions are, I don't know if he wants this stock to trade anymore. I don't know if he thinks he gets another. So he's been paid approximately, and I could be wrong, he's been paid approximately 150 grand over 2 years, approximately, and he's gotten upwards of over 10 million shares of GTI stock, or is entitled to get them. I don't know if he's officially gotten them or is entitled to them. I think we speculated at one point in time that might be up to like 16, 17 million shares, which might make him the biggest shareholder. But if he's already concluded that that the shares are worthless and it's too difficult to make them, then maybe the cash is always he's going to get. Maybe he's thinking, and again, just speculating, and maybe he's already thinking he's going to get out. He's going to get some amount of cash, and he's going to move on to another business. And I've also heard rumors that he's involved in multiple other businesses. I don't know if that's true, but I've heard that. So maybe this is one of many other businesses, and whatever business hits. And again, I'm purely speculating. I don't know any of this to be a fact. I'm just telling you kind of what I hear in the background in general. Perhaps he has 10 other engagements, and if one of them hits, that's great, and that's all he needs. Maybe that's it. But I don't know. But I don't trust him, to be honest, and I know I'm not the only one. And his handling of the audit is, besides the lack of transparency that I deem, that I've seen, just in my opinion, the handling of the audit leads me that direction too. So I'll have to see it to believe it. And I would expect, and there's no reason, certainly, that before, and again, some of the reasons I do these is because I want to put them on the spot. I cannot, so this is how I'm putting them on the spot. I would not, and I'm going to put this in my declaration that I said this, so they're going to have to address it. I cannot believe, in light of what the auditor, what the receiver mentioned over the prior hearings, that we will not have a contract letter from these new auditors before the next hearing. And I'm going to say I did a video also where I put that out there, and I know the Receivers Council watches these videos because they've indicated before. So if that's the case, or they look at a transcript, I don't know. It's going to be a long transcript. They're going to charge a lot of money for this to the receiver. But we'll have to see if they address it. But I would be shocked in light of what the receiver has said in the past and what I'm basically putting them on the spot, that there's not a contract in place. And if there's not, you got a lot of explaining to do. And last but not least, before I get to the end, another thing that made me concerned again, and I've made this point before, but I'll throw it in. Another part about Barton, that was the firm that originally there was a partner, she got pregnant or was pregnant, and somebody couldn't figure out how she could complete the task, or there's a misstep or something, and then they replaced her, and the new auditors couldn't rely upon what she said, and they had to start all over, and then they quit. And I don't think they even concluded this. They estimated all the fees, I think per the documents at least, $225,000, and in the end they've been paid something on the order of $55,000. And I don't think I completed this point, but throughout all these hearings, the auditor was saying that he was indicating they were almost done. All these things were almost done. Makes no sense to me, amongst other things that don't make sense to me, how if they're budgeting 225 and they've been paid 55, how they could be almost done. How is that possible? Is it sound logical that if I've been paid for 20% of the task, that I could be possibly almost done, especially under a situation of structured payments? You had to meet apparently certain milestones to get paid. I don't see how you could come to the conclusion that you would be almost done. Sounds like it also sounds like also an attempt to have a bargain basement deal. But if some guy who had told me it was going to cost me like 250 grand, who I paid 50 to, said he was almost done, I would expect at least to have a knock on my door and say, "Where's my money, buddy?" And then I would expect that would be the reason that the CPA would quit, and that would be the end. But I don't think, in terms of the hearing that we had, where the head of Barton, the same firm, testified in court in Las Vegas about their sudden departure, I didn't hear anything about the fact that they hadn't been paid. Heard nothing about that. So somebody has a lot of explaining to do, as Lucy would say, because it doesn't make sense. If you're budgeting 225, if somebody says they're almost done, I would say I would be concerned if I was getting a deal that sounded too good to be true. We all know that, right? We've all had that experience, wherever it is. Some point in time in your life, I guarantee you, even if it's a little thing, you got offered something and it was too good to be true, and it was too good to be true. I know I've done it. So it didn't make sense. So I don't understand why the receiver wouldn't have been skeptical of those representations and wouldn't have pushed back a little more to say, why are you done? If I only paid you 50 grand and you told me 250 or 225, how could you possibly be almost done? Okay. Anyway, that part didn't make a lot of sense to me throughout. And that's just another factor in there to look at. So going to the subpoenas. So bitching about where the subpoenas, I thought because of the money situation, perhaps that's why there is a stall. And it seems like there really is a money situation. Seems like to me. I would expect that if they borrow money, there'll be some type of filing. I have not seen a filing recently. Perhaps they filed it today. Like I said, anything can happen today. So maybe they borrowed some money. Maybe they leveraged some debt. Maybe somebody's advancing some money. Maybe Paul Strickland is going to be the savior. Maybe he's the one. And again, I have no information to this effect, but maybe he knew that they could borrow because he was going to be the lender. Maybe he was going to put up his own cash. I have no reason to know that, but maybe that's why he was so confident when he was questioned about going forward with the audit, and he referenced they or suggested or implied or alluded to, whatever word you want to do, that there was some way that money could be raised even though there was no cash. But we don't know, but we'll find out soon. So let's jump to our last round of jokes before we head on out, and I conclude with what's on the subpoena. And just to get back to this, what these are is using Claude 5.0. So this is the new Claude version. That's Anthropic's model. And basically I ask it to generate me jokes. And I asked for travel jokes because of what the travels I did recently. Pretty exhausting travel, by the way, when it's like 105 in Berlin, by the way. So now I'm at my question was, I asked another joke. This is the prior set about Germany, and just one, and then we're done after that. Yes, we're done after that, after we go to London. We're talking about Germany. Tried to cross an empty German street on a red light. A grandma appeared from nowhere just to shake her head at me. That's a reference to Germans being very proper. So after that one, and again, each one of these sets, I've asked for 5, and I'm giving you what I think are the best. So just to give you an idea of Claude could use a better sense of humor. Just my opinion. But maybe this is a helpful process about Claude developing a better sense of humor. So the last part is give me really funny jokes about London. So that's my request. The Tube announcer says, mind the gap so often, Londoners now say it to each other during breakups. The Tube is their subway system, which is very efficient. Although when I was there, it was not, because it was blazing hot and they couldn't run it entirely because the tracks heat up so much that they become dangerous at times. At least there they did. And they would show these infrared pictures of the tracks heating up, at least on one side. We also had a amazing thunderstorm over there. 2, London weather forecast. Rain, then a brief tease of sun just to ruin your umbrella decision. And last but not least, everything in London is just a 5-minute walk, which is British for 25 minutes and a rain shower. So that's Claude for today, and I'm putting Claude to bed. That's the highest model. So just to give you an idea, can you imagine Claude, the lower models, sense of humor? All right. Now we conclude by back to the subpoenas. So they've indicated they were going to file subpoenas. There was a dead period. I've been on their case, probably unrelated. July 2nd, they filed something called a notice of intent to serve subpoenas. They're doing it outside of the state of Nevada. And one is directed at the DTCCCC. Can't have too many C's in the DTCC. I think at best they're average. I think a lot of people think they're below average. And they're asking for a whole slew of documents from the DTCC. Now, related to GTII and probably related to Alpine and the transactions. Finishing the cycle about Alpine, one of the things that triggered interest beyond what has gone on before was the apparently 15 accounts that David Reichman, or apparently David Reichman affiliated or somehow connected to GTII, long accounts at Alpine. And there was a period of time, September of 2022, I believe, for about 2 weeks, something on that period of time, not exact, something like that, where there was some investment of $60,000 that grew into $10 million or $10,800,000, which is a pretty good profit. If you can do it in 2 weeks, I think you can make that kind of return. And it's somehow, at least the way I read it, and again, just my opinion, I could be wrong, but it seemed to be suggested by the receiver that somehow that windfall, that money somehow correlated to this short thing. And apparently there was another 5 million shares that are in question. It seemed like something happened. I don't know what's happening about that. I don't know if the SEC has investigated that. I do not know what's happened. I don't know if anybody's reported them as to that specific transaction. I can't imagine at some point in time that somebody doesn't investigate further. I just can't imagine because, at this point in time, there have been depositions, etc. Information's out in the public. I don't think I can only imagine, although I don't know specifically, that there may be tax issues. The IRS might be interested because the IRS is always interested in picking up tax money. As a matter of fact, I've been shocked that the IRS, this has been shocking to me, and they're not quite as aggressive, and it may be too late, probably is too late. But there were properties out there. I'm surprised they didn't go after them. I'm surprised they didn't investigate at least to see if there was a liability. And I don't know what the SEC has done. I don't know, beyond that. I have no idea what's going on, but I certainly think it's in the public, and I imagine that somebody's going to have further explaining to do. So the DTCC, so that gets to Alpine. We have the issue of these long accounts. We have this short trading, apparently. We have, and these 5 million shares and this big amount of money. And was this facilitated by Alpine? And then we have the DTCC, who doesn't want to cooperate. So for a good, and I have to, support what they did to further their inquiry into the operation of Alpine. They subpoenaed records from DTCC. They got an order from the court establishing that, and now we're at the point where a subpoena is going to be directed, or it appears to going to be directed to DTCC to ask for documents. And I expect they'll oppose it, and it may require motions, and this could take a while. But I think eventually a court will permit, at least, I don't know, subject to what. It may be subject to some type of confidentiality, might be some limitations, but I'm a plaintiff, so I can certainly participate. I will be a witness to this, if nothing else. And if I hear things that are inconsistent with the truth, that will be and I certainly won't disclose anything in confidence. But if I see any representations that are inconsistent with the truth, as I've done in the past, and I may not be correct, but I'll certainly give you my view, whatever. So I expect at some point in time that that there will be documents that will be provided by the DTCC as to Alpine and perhaps others. And there may be depositions of the DTCC, and I'm certainly going to request that. And all of you out there who are interested in that should be contacting the receiver to suggest that they further pursue the DTCC and witness testimony by way of deposition. And if they get a response back that it's confidential, they're going to object. Again, could be done per some type of protective order, which is an order the court would grant that makes things in confidence. You can't talk about it. I'm subject to this in this case. So anything I do is I only talk about public information. Information that might be disclosed, like in deposition, that because I've attended a bunch of depositions, but anything that's not public, I don't talk about. And you can continue proceedings like that, and I'm a witness to everything. So no, as far as I'm not going to let shenanigans happen. At least that's my attempt and my certainly my intention all along. So there'll be a subpoena issued. The DTCC will object, but eventually there will be documents. I also expect there will be testimony from the DTCC, and part of the testimony will be GTII, but I think part of the testimony will be about how shorts are handled by the DTCC and how it affects other companies. If you understand where I'm getting at here, and talking about, for example, would some company like MMTLP come up? It's possible. And I've been asked, and I hope they are to their word. I'm certainly going to make an attempt. I was expecting to ask questions at these depositions coming up. I've kind of provided questions to be asked, but I've not taken active participation in the depositions. In the future depositions of the DTCC, Alpine, etc., I expect to be involved and have ability to ask questions that weren't asked by the counsel for the questioning party. And, maybe they'll ask everything, but I expect I'll have certain stuff to discuss. And if, in fact, we get to the point where the DTCC is testifying and the issue about how shorts are handled and the concentrated short position, I just think it's going to cover more than just GTII, and it also might cover topics and disclose information that we would never know about. And that's kind of how things go. If you peel back this case from the start to where we are, we've peeled back a lot of the onion. I'm sure there's a lot more to be peeled back. I'm sure there's a lot we will never know that's been hidden. But kind of, it suggests, if someone wants to be skeptical, they would say the reason why the DTCCC doesn't want to cooperate, amongst other reasons, is because there's some reason they don't want to disclose. Now, I also believe they don't want to cooperate because they don't want to set a trend, and every time somebody asks that they participate. But it also may be the case that they have stuff that they don't want to disclose because it might put them in a difficult position. I still don't understand why they permit Alpine to engage in business if they're claiming that Alpine is a risk or is engaged in misconduct. As of today, I have no idea why they haven't stopped them, why they haven't forced them to put up a large bond. I don't understand that. I also don't understand why they haven't proceeded to federal court, try to get an injunction to stop them. A lot of stuff I don't understand. A lot of the stuff I don't understand the government works. A lot of the stuff, obviously, the agencies, or this is my opinion,
the agencies that are governing this, no, and this is one of those no blank Sherlock, just don't do a great job. And they have limited resources, a few number of courts. And like, for example, FINRA is being paid off or paid, not paid off, but paid. Who pays the money to FINRA? All the everybody that we end up with problems with is a financial contributor to FINRA. SEC has certain immunities, obviously, and protections. So, we're limited. I wish that FINRA was independent and could be sued, because that would make things that would be the first thing I would do, is take away their status and their position and their protection, make them at risk. If they were at risk, they'd be at risk for discovery, they'd be cooperative, and nobody would hide the ball. It's an easy one. So somebody doesn't want that to happen. So they're being asked for a bunch of documents. Then we'll see where that goes. Then after that, once the documents are received, then I'm sure somebody's going to want to take their deposition, and we will see how that proceeds. That might take some months more to go, and I'm hoping that there will be sufficient monies available to be able to do that. I'm hoping that whatever the receiver reflected upon was going to be available to fund the audit will still be available to fund everything that's necessary, including these depositions. So that's one. Number two, the subpoena of two parties. I don't know specifically who they are. I believe that they may be affiliated. Well, I think both of them are affiliated with either the DTCC or Alpine. I believe one of them, and the two names are, so you could look up these names. So the first is the DTCC. The second one is, the witness's name is Dong. I think that's the correct name. Dong, very, very becoming name. Parody. Oh, this can't be a real name. This is the name. I can't imagine this is a real name, but it says subpoena. Just think about, I'm going to let you. I didn't notice this until now. So just listen to what I'm telling you here. This is what this legal document says. I don't know. Maybe this is the name. It's a very entertaining name, in my opinion. Subpoena, and I'm going to spell it, and then I'm going to pronounce it. See if you pronounce it the same way. Subpoena for deposition to Dong is the first name, and Parady is the second name. So the way I would read that would be subpoena for deposition to Dong Parody. It almost sounds like a joke. I'm not trying to offend this gentleman, but it almost sounds like somebody's pulled a joke, because that sounds like a funny to me. But maybe it's a real name. So if it's a real name, I apologize for my crude thinking here. And last but not least, subpoena for deposition to Timothy J. Gtii. And again, for those of you who want to search out this, Timothy, Timothy, J as in J, and last name Gtii as in Cuddihy. And there are prospective subpoenas attached to this. I believe, because I think I recognize that name, I believe, could be wrong, that Mr. Gtii might be somehow related to Alpine directly. Perhaps both are, perhaps neither are, but those subpoenas are going out. Now, might they also object to subpoenas? It's very possible. But if the judge finds their testimony relevant, then they will order them to appear, and they will be forced to appear. And the way it's set up now, I think they can appear remotely, so it's not a big burden on them, just the time. And usually they would hire counsel. So usually if you're going to be deposed and you have concerns, not even if you have concerns, I think it's a good practice anyway if you can afford it. If you can't afford it, then it makes perfect sense why you don't do it. But if you're ever in a deposition, you probably should be represented by an attorney, even if you think there's no there, because because you may be wrong, and it might save you a lot of future money. And I know lawyers aren't cheap. So this was generated July 2nd, just went out. It had dates, I believe, if I recall, August 20th, August 21st. Now, one of them was like for production of documents, and I think, or it might be the both depositions. At least one of those is for the depositions. That doesn't mean the deposition will happen that date. On that date, I think there was like another date that was afterwards. It doesn't mean the depositions will happen on date. And a lot of times, what will happen is you try to set up a deposition informally. So you call up the other attorney, or you send them an email and say, "Give me 3 alternative dates in 45 days for your clients to appear for a deposition. We'll do it remotely, or and I'm going to send you a document request, and that'll be attached." And you might do it that way. If someone's not cooperative, then you often will just pick a date. You'll set it unilaterally, and oftentimes you still have some flexibility. You're going to still let them change the date within reason. The reason why that is the case, because if you go to court, you're trying to enforce a deposition, and you're unreasonable, like the way attorneys are supposed to act in a cordial manner to each other, and you try to get relief from a judge, they won't give it to you and they'll be pissed. So as a result, there's a lot of like this informal discussion that's just kind of performative, that you have to do, or the judges will be pissed. And especially now, I would think we have a new judge. So Williams kind of knew everybody and kind of set his mind, in all kinds of ways, and kind of knew what he was going to do. But this new judge really doesn't have any particular background with any of the parties. And if you were going to appear in front of him, I think you want to make your first impression the best. And you don't want to be accused of, filing improper motions, or, whatever. You want to make a good impression. So that's why I also expect that by the time we appear in front of Judge Hardy, it will be a lot easier for the receiver to defend the fact that he has an ongoing contract with this new firm, and they've started work and they're going to be done. Again, he said 120 days from initiation. I don't think he said initiation, but he said 120 days. I'm going to give him the benefit of the doubt that it's from the initiation of the engagement. We haven't started the engagement, so the clock hasn't started, even though he said this about 90 days ago, kind of to put everything in order. So these subpoenas apparently are going out. I don't know if they're going out. I don't know if they've been served. I'm sure so they, just because they're issued doesn't mean that the parties are bound. So they actually have to physically get served with those. They have to be served in a timely fashion. They have to be served before the date of either the production or the hearing. They have to actually give a reasonable period of time. So you can't, if, for example, just to give you an example, if I set a deposition for you, Renee, to appear for deposition on July 15th, and I didn't serve you until July 14th, that would probably be unreasonable. And if I tried to go into court and say Renee didn't show up, and I served them with the subpoena, the court would probably say, "Come on, you didn't give him, that's not a reasonable amount of time. You didn't serve that." So if I recall, we're looking at in August. So I think the receiver hopes, or receiver's counsel hopes, to serve these subpoenas in sufficient time to give an opportunity for everybody to respond to the subpoenas, perhaps produce documents, object, etc. As I said, it's a process. So there may be informal discussions, and then there may be all out kind of an adversarial interaction. And I'm just going to speculate for you guys, so you kind of think about it. So let's say with the DTCC, they ask for documents, they ask for depositions, and they do it informally. They issue the subpoena, they object to it, they move to quash it. So they try to basically cancel it. And perhaps they have some reason, maybe it's confidential information, something like that. And maybe there's then a hearing, and maybe there's an order from the hearing, and then maybe there's a further interaction where they provide further documents. Maybe they do, maybe they don't. Could be a further hearing. So there could be multiple proceedings. Hopefully it's resolved within a short period of time. But just to be kind of clear, somebody who's taking a position they don't want to cooperate is probably not going to cooperate, and you should anticipate that's the position they're going to take. So that's what I would expect. And I think there might be a lot of you call law in motion matters. Law in motion is all the things that are filed in court, because most lawsuits are a bunch of little proceedings, little skirmishes about a bunch of issues before trial. And those little skirmishes usually resolve the case. So this would be an example of a skirmish. If there is a disagreement about discovery and a subpoena, and there's a ruling, that little skirmish might determine what comes out in terms of evidence, what limitations there are in terms of issues. And there's a bunch of those throughout the case. And that's kind of really what the meat and potatoes is of the case. So we don't know how they're going to respond. I would think it'd be more likely that the DTCC would be more difficult than the individual witnesses. And the reason why I say that, the DTCC probably doesn't have to pay for their legal fees, or they can find it, or it's the government paying and it doesn't make a difference, versus private individuals actually at the front, fit the bill. For these guys, Dong Parody and Timothy J. Cudahy, most likely some private either person or entity is fitting the bill. And so that's different. And so they're less likely, in my opinion, to fight incessantly unless there's something they want to not produce or not discuss. And they think that by not producing and kind of not being forthright, that they can get a better result. And again, I'm just going to leave it at this kind of the end. A lot of people believe, and again, I'm not on this bandwagon, but I think it's a true conclusion. A lot of people believe that if in fact, we at least have hints that the concerns about shorts and of shenanigan transactions, it's not just a hint or an aroma, it exists. So in the end, we don't know what else might be there and what might come out. We don't know what these depositions might yield, and we don't know what companies like Alpine might not have disclosed and might have to, might be willing to fight forever. They've spent, Alpine, I followed them pretty closely. They have spent, in my estimate, millions of dollars in legal fees. And one thing I couldn't understand about Alpine was why, because it didn't seem to me like they were generating that much money. If they were generating, millions, and again, my speculation, my opinion about how much money in legal fees they've incurred, but they were fighting everything in, that at big levels, which cost a lot of money. I'm sure millions of dollars in legal fees. And if you have to weigh one versus the other, are you making enough money to be able to, pay all those legal fees? I don't know. It always surprised me, suggested to me there's something else that's going on, but I don't know. Just like this entire GTII thing, I didn't know. We all didn't know. Yeah, you just kind of have to let it peel back. And that's the one thing I would say the receiver's done a good job in terms of unwinding the part involving the shares, etc. The only problem is for us shareholders, that does us diddly, because without an audit, without a new company, without something getting this to trade, we're stuck here on the 4th watching this extremely long 30-minute video, which this was supposed to be. So with that, after I file the brief, I'll do a video kind of describing what I did. I'm sure that will be responded to, and we can go over that also. If I hear any additional information, I will let you know. I would keep an eye out, for other things that are going on related to GTII. I mentioned I saw a post from Forrester, and I also mentioned I suspect there may be other filings unrelated to or not from the receiver, and to keep your eyes out for those. I don't know if those for sure. That's just kind of my feeling about that. And I think that's it. I don't think I could talk any longer. My 30-minute, 2-hour video. To all you out there, really have a great 4th. Be safe. If you're shooting off fireworks, really be safe. I know the fireworks are much better than they used to be. When I was a kid, we used to have the people on our block, because you go out at night. It was everything was safe back in the 1840s, and we'd go out at night and you're like your corner would kind of bring all its fireworks together. They used to say they were safe and sane. I think it was more safe and insane. And you would like your corner at the corner would light off all these things. I remember those little snakes you would light that would make the sidewalk black. They didn't do anything. And then you would have like one big cone, not like they have today. If you're what's cool, one of the things that's cool about the LA area, this is one of the cool things about the freeways. If you're driving, and the World Cup is in LA, so there was a game yesterday. Spain won 3-0. That's at LA Stadium because SoFi is not a sponsor. But if you take the freeway that leaves SoFi Stadium going north, so in a direction, crudely towards San Francisco, but into the San Fernando Valley, and you get to the top, like at Mulholland, when it gets dark on the 4th of July, and you peer, and the San Fernando Valley is a huge population center and a huge flat space. So when you're at Mulholland, and everybody's heard of Mulholland, I'm sure, you're in Mulholland looking north into the San Fernando Valley on the 405 freeway in the dark, right when it turns dark. And if you look across the entire San Fernando Valley, which, and I've seen this before, that's why I'm telling you this. And so that space is probably from like Universal City, where Universal Studios is, all the way to Topanga Canyon. A lot of you have heard of that. That might be like 20, 25 miles. You will see fireworks going off consistently across the horizon. Everybody, and these are all local shows. This is not an organized show. These are all like local people doing this, but it's all the way across, literally like hundreds of these going off all at the same time, all across the horizon. It is really cute. It's dangerous, by the way, because of obviously the fire danger, but in terms of the aesthetic, it is really cool. So if you're ever in LA on the 4th of July, remember on the 405 freeway at or about Mulholland, take off the road, look to your north, and watch the fireworks show. It'll be really cool. And with that, and that, have a great 4th. Celebrate number 250. That's, again, an impressive number. Thanks for hanging out with me this afternoon. Be well. Take care of yourself. And again, I'll bring up to speed on the filings. And if you want to find out about my travels to Europe, I'm going to do a equally long and boring travel log describing what I saw and what struck me. One thing, just to leave it out, I could not believe there's a pizza parlor across the street from Auschwitz. I just could not believe that. And I'll discuss that in detail and what I thought about that in my travel blog, which I'll put out in the next few days. To all you out there, have a great 4th. Enjoy yourself. Be safe. Take care of yourselves. And I'll talk to you guys soon. Thanks for spending the time with me. Be well.